Constitution. We talked about the Indian Citizenship Act, that sort of thing. That kind of muddies the water because now, after 1924, all Native Americans are citizens. So Talton versus Mays, remember that one? Huh? Talton versus Mays, Bob Talton was the murderer. He was tried in Cherokee Nation court, and they sentenced him to death. And like the federal government, the sentencing came from a grand jury. Okay, so the sentence handed down from the Cherokee Nation grand jury was to hang. But Talton used a defense that the Cherokee Nation's grand jury was only made up of 5 people when a federal grand jury is made up of 16 to 23 people. And he made the defense that this was a violation of his Fifth Amendment rights under the Constitution. At that time, this is 1896, the Major Crimes Act is in force. The Cherokee Nation was allowed to, because it had functioning courts, it was allowed to go through with this. But essentially what occurred was that the federal government said, well, we can try this individual, but the Cherokee Nation has already done that. Essentially what this case tells us is the Cherokee Nation, because it was a sovereign entity, right? It's kind of like ex parte Yoda, but because the Cherokee Nation's sovereignty is not part of the federal government, it's not given from, it's not a branch of the federal government. And at this time, before Native peoples were considered citizens, the ruling was, well, no, your civil rights have not been violated under the United States Constitution because you don't really fall under the United States Constitution's protections. Okay? And so the Cherokee Nation sentenced him and hanged him. So the sovereignty of the tribes allows the operation of its courts on its land at this time. And so what we're getting to is what's the origin, what's the source of tribal sovereignty? That's the question that we kind of get to with Talton versus Mays. Now, Talton versus Mays is important because it recognizes, this is probably the most important facet of that case, that the tribes are not limited by the Fifth Amendment to the Constitution. Tribal exercising of sovereignty is not limited by the Fifth Amendment. Is that good or bad? Well, maybe good for the tribes, but not so good for the members of the tribes, because they don't have the same rights as American citizens who are protected by the Fifth Amendment and later by the 14th Amendment. So we'll refer back to this one when we get to the Indian Civil Rights Act. The Indian Civil Rights Act of 1968 essentially points to this case and says Indian tribes, federally recognized Indian tribes, are not subject to the standards of the Fifth Amendment to the Constitution. Indian Civil Rights Act changed that so that it forced tribal governments to recognize the rights of their people. And in that sense, the Indian Civil Rights Act 1968, was a reduction of tribal sovereignty because the federal government steps in and enforces it. Congress steps in and enforces that. Okay. It was that, that case was one. And U.S. versus Wheeler is a pretty complicated case. But it answers a really, really important question. And so it makes it one of the most important cases in Indian law. It was decided in 1978, and can somebody tell me the scenario, what happened?
There was this guy who was charged with a crime, and he was tried in tribal courts, and he got a lesser sentence than what would have been given in federal court. He tried to say that double jeopardy still applied because
let's clarify something. He was charged in Navajo tribal court initially for something that was basically like a misdemeanor or a low-level crime, contributing to the delinquency of the line. So there was a trial, and there was a defense, and I suppose testimony, and he was sentenced. He was convicted, and he was sentenced to basically 90 days in jail, I think. 90 days, it's probably right here. 60 days in jail, or a fine of $120. No, it was 15 days. He was sentenced to 15 days in jail or a fine of $30 on the first charge, and then 60 days in jail, served concurrently, and a fine of $120. So, $150 and 60 days in jail. That's what he served. Well, after that trial, after everything was closed, the minor female in the case, the victim, reported to federal authorities that she had been sexually assaulted. And so the federal authorities, the BIA police, they charged him they charged him with a higher crime, but based on the very same event. So that's the catcher. He got charged twice for the very same event. The question is that double jeopardy? And I think I asked you last time, if the state of Oklahoma convicts you of one thing, can the federal government convict you of the very same crime? The answer is yes. It's not very common, but it's certainly possible. The reason, and that's concurrent jurisdiction, okay? So overlapping jurisdiction. The good thing about that is if a state convicts, or if a state has the trial and fails to convict, and evidence pops up later, the federal government can use that evidence and convict. And so there's like a safety in a sense. If you're in the law enforcement side, you're saying, well, that's kind of a safety, but make sure we don't have people go free who shouldn't go free. So the question here, and the argument made by Wheeler, was this is double jeopardy because the tribe is beholden to Congress. And the tribe is therefore de facto just a branch of the federal government. Okay? So that was the big question, which led to the ultimate question: what is the source of the authority of tribal government to prosecute? What is the source of the authority? Is it Congress? Does and basically the authority to prosecute crimes is part of sovereignty, the ability to rule your own people and govern your own group. So sovereignty is the question. What is the source of sovereignty? Whoa, that's a difficult one, isn't it? The source of sovereignty, is it with the federal government? And how would you all answer that? And this is it's more complicated than what the textbook relates. If you go and actually listen to the oral argument. because the issue here is the source really with the federal government? Because what is Indian tribal sovereignty in the first place? Is it the same as state sovereignty? And the answer is no, absolutely not. It's not the same as state sovereignty in the eyes of the federal government. It is a dependent sovereignty. It is a reduced sovereignty. Okay? It's sovereignty, but it is not the same as a state. And why is that? Well, anyway, the question was, what is it double jeopardy? Because is tribal sovereignty, is the tribal government just a branch of the federal government? Because it's dependent on Congress for its existence. And
No, I was gonna say, I was kind of confused about the way that it was worded, the textbook, because to me it sounded like they were saying that the tribal sovereignty came from like Indian title basically, because it's like always been there. So
Yeah.
it's separate.
that's the answer.
Oh,
Yeah,
okay.
yeah, you're right. Because that's it. The ruling was that sovereignty does not come from the federal government. Sovereignty has always existed. Just like those inalienable rights of the individual have always existed. It's just they haven't been protected by the Constitution. So the states don't predate the Indian tribes. The Indian tribes have always existed. It's presumed that they have existed since time immemorial. And because those tribes have existed since time immemorial, even though their governments may have been formalized in the 30s or later, their sovereignty has always existed and it predates the Constitution. So there's no way possible for Indian tribes, the sovereignty of Indian nations, to be a branch of the federal government. They're separate. I thought that was a really cool one. I mean, it's a really significant one, and it's 1978. All right, your Senate report here, that document, 1870. We're talking about, this is the chapter on the Constitution. What happened in 1870 or 1871?
So it was like the end of Reconstruction?
Yeah, well, in terms of the tribes, Congress decided to quit dealing with quit creating treaties. I'm not going to ask you to work too much on that, but it's defining Indian, and later on you would have a definition of Indian tribe, or Indian reservation, Indian country, the name of course. All right, we haven't talked about this one, Elk versus Wilkins. That's where we actually left off. Elk versus Wilkins, 1884. This involved a Winnebago man who had been adopted. Winnebago tribe is a reservation along the Missouri River in eastern Nebraska, near Omaha. And this young man was born on the reservation. He's native by birth, but he was adopted and raised in a white family in Omaha. And he was, like an honor student, and never got in trouble. But he was interested in law, and he wanted to vote. So he went to register to vote, and he was turned down because he was an Indian. Because he was a Winnebago Indian, he was not a United States citizen, therefore not able to register to vote. by law. So what did he do? John Elk said, okay, well, I don't want to be a Native American. I don't want to be a United States citizen. Can I become a United States citizen? Answer, no, you may not, unless Congress authorizes it. It takes an act, it will literally take an act of Congress to allow a Native American to become a United States citizen. Okay? And Congress wasn't going to bother with one person. Now, had he had an allotment, could have gotten United States citizenship, right? But he didn't. So he was stuck. He's truly stuck in limbo between, being a tribal member, but he, born in the United States. No, I mean, you can't get more Native than John Elk was, but he was not permitted to become a United States citizen. And the reasoning that the court had was that, and this is the important meat of the case, what this did was it defined Indian identity to be a matter of birth. So the question was John Elk Winnebago before, his feet hit the earth in the United States? It's really crazy, isn't it? But that's what they said. He was Winnebago at birth, and that preceded his possibility of being a United States citizen, because you can only be a citizen of one sovereign. Okay. Now you can get dual sovereignty these days, but you have to work at it. Especially the United States is not real keen on dual sovereignty. If you're in the British Commonwealth, like if you're born in Canada, you can get dual sovereignty in England very easily. But even if you're from the United Kingdom, typically you have to renounce your sovereignty, you renounce your allegiance to the United Kingdom before you become a United States citizen. So anyway, that's John Elk's story. A Native American is determined to be Native American at birth, and that precedes any other sovereign state. So whether or not that is a win or not a win for tribes, I can't really say. What do you think?
Probably not, because we were talking about Tolton versus Mays and how he didn't have access to rights as a citizen. So that's probably not a win, because that just proves that they don't have rights to United States federal courts.
Yeah. So essentially, he was considered an alien, a resident alien.
I feel like it's a double-edged sword. It's like there are some negatives, but there would also be some positives. I assume they didn't. Do they have to pay federal taxes?
Yeah. Well, I mean, yeah, everybody pays federal taxes. You don't get away with that.
The only benefit,
unless you got billions of dollars, I suppose. But,
the only real benefit I could see is I guess he wouldn't be drafted into the army. Maybe.
Interesting. Yeah, I wondered about that.
That's
But
really
there were in World War I. I don't know about the Spanish American War. That'd be an interesting topic to look at. Were Native Americans involved in the Spanish American War?
I believe so.
You think so? Okay. So this is right about the same time, 1896.
I'm taking a 1800s to modern American history course right now, and I believe that was one of the topics.
Maybe if they were citizens, they could join the military.
Or I think it was if you
World
were
War
drafted.
II, everybody was citizens.
Yeah.
Okay. And on the next chapter, chapter 13, recognition of nations, individuals, and land, This is a pretty quick chapter. It essentially provides what's the federal definition of federally recognized Indian tribe. Okay, so those qualifications have to be there for a tribe to be federally recognized. Are there tribes that exist as government, as in their own entity, organized or not, that are not federally recognized? Yes, absolutely. There are some tribes that are recognized only by certain states. But most of the time, those groups are in a process of seeking federal recognition. In other words, they're trying to check off all these boxes. Things like the persistent existence of some sort of political entity, the persistent existence of some community, some sort of authority over people as a government. So anyway, you can read through that. We know that the United States can terminate tribes, and when they terminate a tribe, those tribes lose federal recognition. That doesn't mean they can't continue to exist as they had, but it just means the federal government no longer considers them legit as a nation to work with. Okay, United States versus Cruz is it's another case of an individual claiming to not be a Native American. And in his case, he was a blood quantum portion of two tribes, one tribe located in Canada, so it wasn't a federally recognized tribe. He was 29/64ths, let's see, he was 29 1/28 Blackfeet and 32 1/28 blood. The Blackfeet tribe is federally recognized, so they're located in Montana. So the question here is he is subjected to what's called the Bruce test. The Bruce test was developed in a case in 2005, which you haven't read about and is not in your text. But the Bruce test is a test for membership, let's see, a test for Native American status as an individual. And you can see that there are 7 facets to an individual's Indian status. Those are tribal enrollment. Let's see here. The factors that govern. It's a two-prong test. Number 1, the first prong is blood quantum, which was, documented in tribal membership and descent. And number 2 is the big one. Number 2 has all of these different facets. It's membership of a federally recognized tribe. Membership within a federally recognized tribe. How do you determine that? And so for that second prong, there are 4 factors in declining order of importance. Number 1, tribal enrollment. Number 2, government recognition formally and informally through receipt of assistance reserved only to Indians, like health care, for example. Enjoyment of the benefits of tribal affiliation, whatever they may be, like perhaps per capita payments or something like that from casinos. Number 4, social recognition as an Indian through residence on a reservation and participation in Indian social life. And Cruz, well, why is he not wanting to be identified as an Indian? Well, he was picked up on some crimes. And, let's see, it was an assault charge, I think. Third paragraph on 274. Anyway, it's not real clear exactly what happened, but he was in an altercation, and the woman that he had been seeing was received a real severe injury, and so he was arrested and charged with assault resulting in serious bodily injury, and he pled not guilty and went to trial, where his Indian status was a contested issue. So. Again, jurisdiction. It's all about jurisdiction. Was it state jurisdiction or was it federal jurisdiction? Anyway, the question was, okay, he was an enrolled member of the Blackfeet tribe. That is because his mother was, and he had descendant status, even though I don't think he had a CDIB card, he didn't have a certificate of degree of Indian blood, he was obviously a descendant of a member, and who was, would have been what? She was, I guess, 51, 64th, whatever that is. Okay. Anyway, so he was obviously a descendant, but he had never taken advantage of any of the benefits, services as a tribal or as an Indian, and he didn't have any benefits from the tribe, although he lived on the reservation for a while. He had attended public school on the reservation, and he had never participated in any sort of cultural stuff. He actually he identified more as Hispanic, I think. Anyway, he didn't satisfy any of the 4 Bruce factors, according to this, on the second prong of the test. So the government could not declare him to be an Indian. So the majority opinion of the court further refined the second part of the test, declaring that 4 factors of descending importance aided in determining whether an individual was recognized as an Indian by the federal government or tribal government, although the dissent vigorously disagreed that the points were in descending order of importance. So it was a close, fairly subjective call on this one. All right, well that's the one case about individual identity. The recognition of nations is the rules that the federal government requires for a tribe to be federally recognized. So they have to satisfy all of those items to be federally recognized. The third one in this chapter is very straightforward. It's Indian country, and that was defined in what the courts will often refer to, or the lawyers will often refer to as 1151. The United States Code, subsection 1151, and then it's amended, no, that's not amended. 1151. So that's the 1948 formal definition of Indian country, and this gets complicated. Well, it gets confusing. It's not that complicated. Indian country means all the land within. Be sure to know this for a quiz. Okay. Indian country is A, all land within the limits of Indian. This would be very much an essay question on this. Okay. Land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. So, any land within the limits of any Indian reservation is Indian country. Therefore, reservations over there, it's all Indian country. Okay. Now, it's not to say there wasn't Indian country before, because restricted allotments and tribal lands were Indian country. Casinos are all on Indian country. Tribal smoke shops are all on Indian country. Retail gasoline service stations are all on Indian country. They have to be in order to operate. and not pay state taxes. So there was lots of Indian country was just incredibly checkerboarded. With the creation, with the McGirt decision, now we have 5 large reservations, and everything is considered Indian country. Okay. B, and that was what the Creek Nation, when Creek Nation took up this, you know, they didn't want to defend McGirt. You know, he was a pedophile. But what they wanted to do is make sure that, you know, their land was recognized as a reservation. And that's what they went by. They went by, well, they went to the various treaties and federal legislation, lots of legislation that attempted to remove and actually did shut down the Creek government, but it never eliminated the reservation. In effect, they, you know, the Creeks were sort of terminated in all but a formal termination. You know, the Congress did everything to shut them down, and all the 5 tribes, but they never said you're terminated. And allotment was just assumed to have, you know, to dissolve the reservation. all of the lands that were sold, like sold to individual claimants to, you know, non-Indians, timberlands, coal lands, and urban areas that were segregated from allotment, the proceeds of all that went to the tribe to be redistributed for tribal business. So in a sense, they didn't sell it to the federal government, okay? Well, what was the defense of the state of Oklahoma in the McGirt case? What did they call the Creek Nation? They called it B, and they called it a dependent Indian community. So, according to 1151, all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state, that's a dependent Indian community. And then all allotments, the Indian titles to which have not been extinguished, including rights of way running through the same, is Indian country. Right? So the state of Oklahoma acknowledged, of course, all of the allotments, all of the tribal land. Well, yeah, that's Indian country. But in terms of an entity, the population was considered a dependent Indian community, but somehow they got to that, okay? But anyway, the state lost 5-4 on that.